read the balance of Dan's comments before I say anything. I made a couple of comments personally. And I hope it makes sense. Details of alternative proofs must be more amply spelled out and can only apply to cases of verified misadministration. This is one of my comments. Not to any post-2006 vacancy decontrol increase, because repeatedly I've heard personally a lot of people from MSTA talk about this case in 2006. So obviously we know about it as of 2006. So any of this alternative documentation, we're trying to correct misadministration. So I would think it appropriately should only apply pre. I know it's Dan's comments, but I wholeheartedly agree. There must be proof that the tenant vacates the apartment voluntarily without harassment. Oh, this is quoted from the ordinance now. This must be proven. Oh, okay. This will go to the record. Some suggested alternatives, I guess. This must be proven by obtaining an affidavit from the vacating tenant affirming that his vacating is voluntary, or by court documents which verify that the eviction was legally ordered by the appropriate court. Similarly, rent increases must be verifiably legal, such as cancel checks and other verified costs of living increases. There was some discussion that the only people who might be able to verify that somebody left voluntarily would be the actual tenant. Some concern about that, but there actually are other means I could verify for you. Any tenant that lived in my building in the 27 years that I lived there did leave voluntarily. So if you can just, leave it to let the rent leveling board have some discretion here, but it should be able to be verified. Now, a couple of my quick comments. And I do want to respond to a couple of things that were said earlier. There was some concern that, or, you know what, I'm going to skip that because I'm not sure what my notes say. One thing that's concerning me tonight is a lot of missing paperwork is the reason we're here and records not kept well. And yet I've heard the MSTA group come up here and say, well, we don't want all this paperwork now. So, please try to balance that. We want things to be documented and verifiable, or we don't. I do understand use of the internet. I'm sure you folks know this, but I do want to say, since we did hear the realtor report earlier, that this is not all about realtors making money, how much buildings are selling for. I've asked the question, do rent controlled buildings, are they taxed less or not? I have heard, similar to what Scott Siegel said earlier, that it's the quality of the property, it's the location of the property, not so much the rent. So that is bogus. I did, for a brief period of time, about 6 months, do distressed real estate conferences. I asked attorneys, why are condos taxed higher? And the answer was they just are. So to try to blame the tax rate on rent control properties on the tax rate because they're rent controlled, I don't think it's real. Also, we keep hearing, I want to second what Kathy Cardillo said, we do try to create a sympathetic portrait of senior citizen landlords. I'm sure they exist. There are also a lot of older tenants, particularly the ones who are most targeted now, who lived here the longest, where there might not have been a lot of vacancy turnovers. And as far as, if I ever hear this, let's remove 1 through 4 buildings from rent control because they're going condo, basically you are ending rent control in Hoboken. The majority of our remaining rent control properties are 2 to 4 family buildings, so you can't even go there. I think that's everything. If I think of anything else, I will send it in. Thanks.
Thank you very much. Mr. Carl Pershing.
Okay, I would like to say that as far as this goes, I don't find a lot of objections to it, but I find it is very incomplete. First of all, I'd like to ask the panel if they have any statistics on how many total housing units we have in Hoboken, how many and what percentage are rent controlled, And of those, how many and what percentage are 2 and 3 owner-occupied buildings? Do you have them? Did they play a role in your deliberations? I remember when Anthony Russo was mayor, he attempted to modify some of these regulations, but he came up with all kinds of statistics that were made available, that were presented, because in the absence of that, we really don't know what we're talking about. And what I have in mind specifically is all the subsidized housing that's coming off government programs, for example, applied housing. How many units are we talking about? And I think that the people that are most concerned with protecting tenants' rights, maybe almost to the point of feeling that they're going to be screwed if one step at a time. I'd like to direct their attention to the bigger picture about the other people who aren't being protected. And I think it's very important to see things in context and put it together, not just talk about an unknown number of units that then take too much importance maybe if we don't know what the number that we're talking about. So do you think that could be made available, or do you think that that should be part of the discussion? What do you think? Okay. There's another little thing. Increases due to inflation are kind of automatic. You get the number, the percentage from the rent control board, and it goes through, and when you fill out your new form, you put down you increased it so much because of inflation. Why aren't tax increases treated in the same way? Why is there a completely different procedure that's much more awkward, not as easy when it comes to tax increase? So, I mean, would anybody object to that? Okay, so when am I going to get my statistics? What?
We can talk afterwards.
Okay. Okay, thank you.
Ms. Rebecca Lewis.
Hi, Rebecca Lewis. I'm at 822 Garden Street on Ground Floor. I'm just going to make a couple quick points. First of all, I want to thank you for all the hard work that you're doing. I know it's a hard job to try to balance the tenants versus the landlords. Actually, as a member of CRAW, we did recommend a 2-year statute of limitations on collecting back rent. Not all members agree with that. Those members that submitted our proposal for CRAW did that. One thing, I'm not sure from the ordinance, the amendment, that the notice is tied to putting in that statute of limitations. I think that's important, that they have noticed that that there is a rent control law in Hoboken, and that and the rent they are paying is not necessarily the legal one. That can only be determined by having a rent calculation by the rent controlling office. And so that's my main thing to say. I do wonder about the statistics too. They keep saying 8,000, but that's 8,000 people that have actually been registering. That doesn't mean that there are lots of other apartments that haven't. And also, especially like a condo owner doesn't know that if they're renting their condo unit, they're supposed to register too. and that their increases are subject. So statistics would be nice. Okay, thank you.
Thank you so much. Steve Silverman?
I'm going to give my speaker time to Sean Smith.
I'm sorry, again?
Sean Smith.
Hi, good evening. My name is Sean Smith, and I'm an attorney at the law office of Brock High Court. My office was appointed by the New Jersey Superior Court to represent all landlords in the city of Hoboken in a certified class action whose properties are subject to the rent control ordinance. By way of background, the class action complaint was filed about a year ago to redress the city's, and more specifically the rent control board's failure to uniformly administer the rent control ordinance over the last 25 years. In that action, property owners have asserted and continue to assert that the city's actions, which continue through this day, violate those property owners' constitutional rights both under New Jersey state and federal constitutions. On April 1st, 2010, the court certified the matter as a class action and appointed my office as class counsel. The class action allegations arise that the rent boards, through its rent regulation officers' actions in the administration of the ordinance, and in particular the performance of legal rent calculations. Through our investigation, and in fact through our prosecution of another prerogative writ action against the city involving another individual case, we've uncovered that the rent board changed its methodology of enforcing the ordinance multiple times over the 25-year history. In fact, what we've learned is that similar problems were identified not just by our office and our expert who performed a statistics sampling, but by this city in 1996, when the Hoboken Task Force on Rent Control Revision and Modernization issued a report to make specific amendments to the ordinance. Unfortunately, that report fell on that council's deaf ears, and no changes were made to the ordinance or the process of administering that ordinance. Now, today we're pleased that the class action complaint has been a catalyst to begin to correct the problems in Hoboken's rent control market. While we will continue to work with your council in this matter, we wanted to express that the proposed amendments to the ordinance provide an important foundation to resolution of the class's claims, as the amendments redress many of the allegations asserted by the class. Of course, all ordinances and administrative processes can be improved. Some of the suggestions you've heard tonight can improve the situation and further redress the complaint brought by the class members. These include further updating the base year to 2006, when a Superior Court decision came down and established a process by which information and filing should be made on a going forward basis. This would eliminate the unnecessary and unworkable paperwork in the administration of the ordinance. However, the class representatives have directed us to advise the council that the proposal as drafted does provide the foundation for substantial relief to the class without compromising the rights of the tenants. We look forward to continuing to work with the city's council to make the proposal even better for everyone concerned. One issue that we wanted to raise is the 8,000 figure. It's a figure that comes from your tax office. It's as an assessment. It's not a number that has been picked out of thin air as may have been suggested. In addition, we have provided expert sampling and reports to the Superior Court in a matter involving the city litigation to 6 Corporation. That report was considered by the court and ultimately resulted in, as part of a judicial determination, finding that the way that the ordinance was previously enforced was in fact arbitrary, capricious, and unreasonable, and therefore unconstitutional as to that particular property. Thank you.
I want to say how appreciative the committee is for, especially a room this size with this many people, being able to express their positions and do it in a very congenial way. We greatly appreciate that and look forward to moving forward with discussion on your resolutions and moving into the council. Thank you very much.